Welcome to Behind the Deal, where we'll be exploring unscripted, candid, first-hand experiences about the wild successes and cautionary tales of professional investors, founders, consultants, and advisors as they share their stories in deal making. Welcome to another episode of Behind the Deal, where we are exploring some of the interesting experiences that happen in the deal-making world. Today, I am joined by business trial and litigation partner at Bell Nunnally, Ross Williams. Ross, thank you for joining. I'm really looking forward to this conversation. I've been looking forward to it for a while. Introduce yourself. Tell us about you. Tell us about the firm.
Thank you, James. Thank you for having me. I'm Ross Angus Williams. I am a litigation partner at Bell Nunnally and Martin. I've been here since 2009. I've been at this firm my whole career, except for a clerkship I did for a judge for a year before I started private practice. Our firm is a full service business firm. We do both litigation and transactional work. It's easier to probably list the things that we don't do. But if it's in the business world and it's a legal issue, we probably handle it. My practice is very broad because the way we train up attorneys here is everybody works with everybody. We only have two sections. One's litigation, the other's transactional. And so the easiest way to say what I do is if there's a contract and two people that hate each other, that's what I do.
Yeah.
So it's a great firm. Love the firm. And happy to be here talking with you.
Yeah, you've been with them for a long time, it seems. So I know you've definitely got several stories, and hopefully we get a few of them out of you in this time. So let's get to it. Tell me a story.
Sure. So let me just say, like they used to say at the beginning of Dragnet, if I've just dated myself, but the names have been changed to protect the innocent. A lot of the stories that I have are covered by confidentiality agreements and settlements and stuff like that. And client confidentiality, of course. And so I'll change around some facts. I'll change around some names or not give names. And that's just because I have to. I wouldn't want anybody to think that they'd come and hire me or the firm or enter a confidential settlement agreement and that we'd be out here spilling the beans on an interview. And so I just trust that anything that I say will sound like a story and it will be somewhat fictionalized, but it'll be based on true events.
Fair enough. I like it.
Yeah. So with that, I am thrilled to get this opportunity to be sitting here, talking with you and with any folks that are on the deal making, on the business side of the world about the things that I see that just come up over and over again, that become problems in cases that cost the client a lot of money in having to litigate and fight about things that there really shouldn't be a fight about. And so over the course of time in my career, I'm looking at my notes over here. I've got it, like it's etched in my brain now, a list of things that you just see come up all the time that are avoidable. And so I'm just going to kind of go through those.
Yeah.
A lot of them are going to seem really obvious. I would think they're obvious. I can tell you from experience, they're not. They might be obvious, but they're not done. And so here we are. So the first one the first point that I just see over and over again is read your contracts, right? And I'm not talking about, you have contracts of adhesion where it's like sign it or don't sign it, for your credit card statements and stuff like that, or your cable bill. And that's not what we're talking about. We're talking about sort of bespoke deals that you enter into in business. Read your contracts. The first attorney I ever worked for when I was in law school was a guy named Jan Humphreys. He's passed away now, but he's a great lawyer, and he used to love to go into those contracts, like the contract. The one he always told me was about his contract with his credit card company, and he would go in and he would make changes, and he would sign it and send it in. This is before the age of DocuSign, all these things, okay? And then they would come back and say, they'd send him a demand, you haven't paid us or this or that, or you haven't paid enough, or, your interest rate's this. And he'd say, well, no, it's not. I've paid you everything that I owe you. And they would go, have you read your contract? And he would say, have you read our contract? And then they would go back and look at what he signed and sent in and that they'd acted under. And it was a very different world. And that's because they got it back and extended credit and didn't read what the terms were that they acted under. So
That's fabulous.
now you've got DocuSign, all those things, and they've got provisions in there too that are going to prevent people from doing that. But back in the day, that was a thing. So there's an example.
They had to learn the hard way.
Yeah, so I've got on the read your contracts point, give a couple of examples. You've got a services agreement, right? Services agreement clearly says in there, this guy is performing a service. You're only going to have to pay if a deal closes. But it also says that, if you get to one of these various sort of stages where something happens and he's gotten you to a certain point, if you don't go forward with the deal, you owe him the money, right? And you would be amazed at how many folks in just that kind of setup, we get it. There's a lawsuit filed because we sent a demand letter that said you owe the money. We get into mediation or just an informal settlement discussion or what have you. And the first point that you hear back from them is, we had no idea that was a provision. And we thought that we only owed him money if the deal actually closed. All these terms they're not crazy. They're reasonable, right? At some point, the guy has done the work and deserves to get paid, but it just comes up over and over again. And if they've got counsel on the other side, that counsel's telling them that's just not going to work. The law says it doesn't matter whether you read your contracts or not. Actually, if you sign them, you're stuck.
Is that more along the lines of for like a broker of some kind, or
it can be in a brokerage? Yeah. There's all kinds of other, so for like business brokers, for instance, folks that are doing any kind of consulting work that's on, a sort of more of like a contingent arrangement. They might be taking a little bit of a retainer, but they're working towards some sort of a deal or some sort of a savings. You got folks out there all the time that are like, we can save you this much on your, fill in the blank on this or that bill for your overhead, right? And this can amount to, their fee or commission on this thing could amount to hundreds of thousands of dollars. It's not no money. Okay. It can be really significant. And I just see it all the time. Folks don't read. Wow. And then they think that they can, that they can go and let somebody do a bunch of work and get them right to the goal line and then just get cold feet and back out and they're good to go. And that's just not the way that those contracts, those types of deals are typically written.
Interesting.
And what that person, and I'm not saying anybody I've represented has done this, but what that person said to you before that deal was done, or even really what they said to you after the deal was done, because the contract probably says that amendments have to be in writing. It doesn't matter. It doesn't. And so that's one sort of story that I've seen come up over and over again on the read your contracts front. Another example of that is, in the law in most states, it's the law that if you've got a dollar amount written out in numerals, and then you also have it written out in words control, not numbers. And so if you've got something that says, I'm going to pay you $1 for this, $1.00 parentheses, and then the words $250,000 are spelled out, you owe $250,000.
Oh, wow.
So that's the law in a lot of states. And, if you don't read your contract, you don't catch that, it can be a big problem. On the other, and a similar one is with decimal points versus commas. If you think you're doing a deal for $1 million, but you put in any of those spots a decimal point instead of a comma, then that's what it is, right? So if it was supposed to be 100,000, you put in 100 decimal point with a bunch of zeros, it's $100, and that's it.
Which one takes precedent? The one with the one
Well, the
that's
period,
lower
period.
or the
However it's written out is the way it is. So if it was meant to be a comma, but it is a decimal point, wherever that decimal point is same thing if it's a comma instead, right? Whatever
okay?
it's written out and it reads as, even if it's got a bunch of zeros after the decimal point, that doesn't matter because you can have fractional pennies,
Yeah,
right?
I see what that. I
And
see how that makes
yeah,
sense. Yeah.
so I've seen it go both ways, and that's another one that is out there that it doesn't this happens because people don't read. They don't
Wow.
read when they're drafting. They don't read when they're signing. They
Wow.
just sign. Okay, take the time. Have somebody. If you're a busy person, you're an entrepreneur out there doing the thing. Have somebody that's not as busy as you reading, with the
I
whole
mean,
job of making sure that these things aren't in there. Right? I've seen this come up, and it's come up in
10,000.
cases that I wasn't involved in too.
ten
Um,
thousand to 100 grand is a huge difference,
it's
or
a huge difference, and 100.
hundred
Yeah, I've
grand a
seen
million.
there's been millions, right? There's been
Yeah,
millions that were hundreds instead.
yeah,
Um,
that's rough.
so another big one that comes up over and over again is, and it comes from people not reading their contracts, is choice of law, choice of venue, choice of forum. I'm not saying that if the person you're doing business with is based out of Texas and you're based out of New York, that you should be scared about litigating in Texas. That's not what I'm saying. What I'm saying is, if you really want to be in New York and your contract says Texas and Texas law, and you sign it, you're probably stuck.
Yeah,
Um, if it says this contract will be governed by the law of the Philippines, and we're agreeing to arbitration in front of this arbitration group in the Philippines, I don't know what the law of the Philippines says, but it's probably not good for you. It's probably good for
probably.
whoever put that in there, right?
Yeah, right,
And
right.
so these are all sort of examples or war stories where I've seen people not reading their contracts come into play in a way that it either makes a case so much more expensive than it needs to be, um, or it's going to make the thing so complex and subject to so much back and forth that the case ends up settling really quickly. Sometimes that's good for me,
Yeah,
sometimes or my client, and sometimes it's not good for my client, depending on who's on which side. All these things that I'm saying, these are things that ultimately cost me money, because what I do is I fight about what contracts say and mean. So I'm by giving you these tips, I'm saving you money, but I'm costing me money. So
yeah.
if that makes it useful to listen to this, then please
No,
do.
absolutely. I'm
Yeah,
taking my own mental notes, and then
yeah.
this will be out there in the world too. So this is great.
So that's the first big one, and I think that any litigator would probably have that as the first one in their mind. The second point that I would give from my experience is, fill in the blanks in a contract. If you're working off a contract that has blanks, fill them in. I've seen contracts where there's a blank for effective date, and it's
Right,
not filled in because it's the
right.
top of the contract and everybody signs at the bottom, right?
Yeah,
And at the bottom there's no blank for the date, right? So now we've got a contract that keys off of the effective date, and we're going to have an argument about when it happened. Could have happened last week, could have happened 5 years ago. How much is that in interest for you? What's the
yeah,
significance of that? And do we want to spend you know hundreds and hundreds of dollars an hour times however many attorneys you have on the case litigating over what that date was, or just look for blanks and make sure that they're filled in and filled in
yeah.
the right way. Um, Another example that I've seen, you've got blank. It could be anywhere. It could be in the top of the contract, could be somewhere in the middle, could be in the signature block, but there's a blank somewhere to fill in the company name of the company that's going to be obligated on this contract. And somebody's busy, they're in a hurry, they don't even notice it as a blank, and they sign their name and they write their name under the little deal that says name, or they just sign it, right? But they sign it in a way that you can tell or figure out who it was that signed it.
And that could be opening up again, to signing something personally, couldn't it? If you don't
That's what I was
sign
just about to
directly with
say.
your title, right?
Yes.
Wow.
If you don't put the company name in there, there's two or three different arguments as to why you may have just obligated yourself personally,
Oh, wow.
which is, for sharks, that's blood in the water. Okay.
Yeah.
We always, litigators, if we're on the plaintiff's side, we always want the individual to go after, because you get a judgment and say you can keep it alive forever. You can keep a
Wow.
judgment alive forever. And, even after that company's long gone, if you're individually liable on it because you just didn't fill in that blank, which is a thing that I have seen happen time and time again and
Wow.
argued about and won if I'm on the plaintiff's side, or argued about and lost if I'm on the defendant's side. It just fill in the blanks. They're there. Look for them, and make
It's
sure
the
they're filled
simpler
in and
stuff.
filled in the right way. I've also seen ones, and this goes to the next point, right? Point 3, check the names. The
I was about
names
to
that are
ask
in your
about that.
contracts, you have to check them. A lot of times you have um, an agreement, a security agreement is a separate document. Sometimes there's attachments with cap tables or other kinds of tables, and then you maybe have amendments to those or forbearance or those kinds of things. I've seen cases where in each one of those documents there's a different entity that's listed as the obligated entity. And so what that results in, if you've got attorneys on either side of the case, is a ton of argument, motions practice, um, court hearings, uh, deposition testimony about, research about who was obligated, who actually signed, and why, right? And so it might be that your attorney can connect those dots, and the person or entity that you want to be obligated is, and it might be that they can't and they're not. And so
Yeah.
you would think that this is obvious. All these, you would think that this is an obvious thing, that you check the names, you make sure it all lines up. When folks are in a hurry and they're trying to get a deal done and move on to the next deal, or they whatever it might be, they just don't check these kinds of things. So check
So
the
is that,
names, and it's not just a completely wrong name, okay, like a totally different name.
yeah.
Sometimes it's you didn't put the LLC on the end, or you didn't have the correct legal name.
So that does
They all
matter.
this company always goes by this name. That's the name on their card,
Yeah.
right? But their legal name is something completely different.
So you have
And
to use the legal name, not like a DBA or anything like that.
well, you want to use the legal name, right? You
Yeah.
want to make sure that's in there. Sometimes they have a legal name and they DBA, they do business as somebody else, right? That best to have all those things in there, but have them all and have them right. Um, I ran into a situation in the last quarter, right, where um, there were two entities with exactly the same name. One was, we'll just say for purpose, it wasn't this state, we'll just say for purpose for the example, one was uh, formed in California and one was formed in New York. And so it wasn't specified in the deal docs who was where and what they were doing, right?
Yeah.
So that is one level of complication. And now if you have those two entities with the same names in different places, what if one declares bankruptcy? How do you know which one was yours, and if it's in bankruptcy, and if you can even go forward with your lawsuit, because you might be under a bankruptcy stay? Okay,
Wow.
how do you know?
Yeah.
They're going to
So that,
say that you're stayed, you're going to say you're not. How are we going to prove one way or the other?
that would be like when you've got the company name LLC located at that address.
Yeah.
Is that what
So
you're saying?
you can put an address. That's a great way to do it. You could put and you get almost all of the secretaries of state have free records that you can go and view, right? And so you verify with the person on the other side of the contract, y'all are an entity of what state, right? And then you say, so let's say so and so LLC, a California limited liability company, for
Right.
instance, right?
Right.
um, and so that way you're just making sure that it's clear, objectively clear, not just clear to you, um, who it is that's in this deal, and who's going to be obligated. Checking the names, right? It's another one that just comes up all the time. And as soon as it's not done right, if that deal, just like all of these, if that deal doesn't go the way everybody wants it to, and it ends up on the desk of somebody like me, well, we're going to be fighting about it. We might be fighting to keep it, or we might be fighting to break the deal, depending on who I'm representing. But it's going to be a fight,
Yeah.
If you're a plaintiff on something, you want as few hurdles as possible. You want it clear, clean, no question about anything in there. Because if you're on the defense side, you want as many hurdles as you can. The more it costs, the longer it takes, the more people tend to get discouraged and give up. Right?
Yep.
Attorneys use these things depending on which side they're on, who they're representing. And
Yeah.
so I like it to be clear and clean if I'm on the plaintiff side, the one that's trying to enforce the contract.
Yeah.
And there's a saying in litigation that I use all the time. If you're explaining, you're losing.
Yep. I love
It's
that.
true. It's true in front of the judge. It's true in front of a jury. You never want to be on your back foot. You never want to be having to explain anything, because if you're explaining, you're losing.
Those are some serious words to live by right there. For those that are watching, I would definitely write that down.
Yep. Another one. Another example of that is with the check the names is forms. If you use a lot of form contracts for things, it is a very, very common thing I've seen come up over and over again, where there's a blank that's filled in, or a field that's filled in somewhere with a name, and you're going through and doing it maybe by hand or quickly, and you don't catch another place where there's a different name. This can create an ambiguity in the contract.
Yep.
That again it can cost a lot of money, and it can prevent you from getting a summary judgment sometimes. So
do you have all 3 or 4 of these points are amazing to me as it is. I'm sure for those that are outside of law, I'm sure they're like, I had no idea any of this was, now I need to go and call my lawyer and make sure everything is filled in properly. Do you have a specific case study, or maybe a story about one of the experiences that you had with any one of these kinds of landmines, if you will, where it might have ended up costing them either the company or anything along those lines?
Sure. Yeah. Let me see if I can give you a specific example about one of these. Yeah, I've got one. And again, anonymized, or some facts changed here, but it follows a pattern that's true facts, right? Cigar producer and distributor, right?
Okay.
Got and the creditor on this deal has got security interest in all of their stock. It's really interesting how cigars are produced and how they age, and where they're stored and all these kinds of things. And they're valuable, so that's a valuable asset.
Yeah.
Well, the security agreement has, the name, we'll call it Up in Smoke Cigars. Okay. That's on the security agreement. The promissory note has the name Puff of Smoke Cigars. Turns out that the guy that owns the cigar company, which has a brand, and the brand is Smoke 'em while you got 'em cigars.
That's good.
He actually owns both of these company names, and is going to come in and argue, well, the security agreement is actually with the company that doesn't own the stock. The security agreement is with the is with the is you know the company that owns the stock is on the promissory note, but they're not on the security agreement. And so, yeah, you've got a security interest in all of this stuff that this company doesn't own, right?
Yeah.
So, how does that get worked out? Well, the way it gets worked out is you're probably getting a judgment, but you probably don't have assets to foreclose on. So then you're going to have to do another thing that I do is enforce judgments. So now you're going to have to try to find their accounts, try to find, do they have other assets? Can we just hound them until the end of time and hope that they agree to pay something?
Yeah.
It's not as good a place to be in as making sure that who the right person is that actually owns the assets, and that's who you've got listed under your security agreement. And at the end of it, it's better to have more names than fewer. So if you get into that type of a situation and you've got a bunch of names, ask that you have a security agreement that covers all of the assets of all of the names that are involved. And if you can negotiate for that and get it because the other side really needs money and you're extending credit to them or money to them,
Yeah.
that's great. Now you've got whatever you can get. But that's an example based on facts that I've actually dealt with. It comes from that example of not checking the names in the contract and not reading. It all goes back to not reading.
Did that company encounter a problem, or did maybe like an investor encounter a problem with them with the cigar distributor?
Oh yeah, they didn't pay.
Oh,
They didn't pay the hundreds of thousands of dollars in credit, and it wasn't, as I said, it's anonymized. It wasn't actually a cigar distributor, but
right.
They just didn't pay. This hundreds of thousands of dollars was extended, and
In credit.
Yeah, and who knows what happened with the money.
Wow. So is that one of the instances where the distributor was lent credit but didn't pay it back?
That's right. The producer, the producer of the cigars got credit to go and do all the production, all the labeling, all the packaging. All of these things are expensive when done at scale, and as far as you can tell, they just got that money for free.
Yeah, they didn't have to pay it back, and the creditor didn't have any recourse to recoup it.
Well, you can go get a judgment, right? But if you got the wrong name, you got a judgment against somebody that you can't get anything from.
Oh,
you see, and so this goes back to, don't when you're doing your contracts, do the deal, over a cigar and a glass of whatever it is that you might like to drink, milk or beer or whiskey or whatever it is. But prepare, review, and sign the documents in the sober light of day.
Is what I would say.
You see what I mean?
Yeah, that's good. That's good.
Yeah. Let's see. A couple other points that have come up over time. They're just, should be burned in everybody's mind. Attach the attachments.
Yeah.
I've seen cases where it's got a reference to a security agreement. It's got a reference to a cap table. It's got a reference to whatever it is that you didn't want to include in the agreement itself because it doesn't really lend itself well to being in the middle of a bunch of text. And then either that thing's not attached, or worse, it was never drafted. So imagine now this is where our deal is supposed to be. You get this percentage, you get that percentage, you get that percentage. And now that thing was never created, and so it's just a he said, she said about I was supposed to get 99%. You were supposed to get 1%, right?
Yep. I can only imagine the ramifications on that.
I've lived it. I've fought that fight. It's great to be in the spot of the person that's trying to get out of the deal if the attachments were not attached or maybe never even existed.
Right. I can imagine so. So you want to give us one quick one more quick one
Yep.
of a story that you went through.
So this is one that will encompass. I can roll together a couple, and I can tell you a story about it.
Okay.
This point is keep track of and control of your documents, your information, and your accounts.
Yep.
I have seen situations where people own a business together, and um, the person who is the majority owner in the business, uh, they've paid to be that in that role. They do not have control of the bank accounts, the CRM, if it's a job, if you keeping track of your job status, right? And there's a program
Yeah.
for doing that. They don't have control of that. They don't have control of signed contracts. They don't even have control of maybe even their communications, right? Because there's an email account that everybody's got an extension for, that these all go back and forth on, and they don't have the login for it,
And this
right?
is when you like login information, and then are you also talking about physical possession of documents as
Yes,
well?
both.
Yeah.
So
Yeah.
so the parties get sideways, and they want to, the party that maybe is the majority owner wants to break up the business and take their percentage and sell it or cash it out or whatever.
Yeah.
And the next day they're locked out of everything. And you call the bank and you say, hey, this is, I'm the majority owner of this business. I need to get in this account. Well, we don't have you as a signatory. We don't have,
They can.
we they either can't or won't do it because they don't want to expose themselves to potential liability.
Yeah.
You can't get into any of those other sort of business databases, CRM, job tracking, any of those kinds of things.
Yeah.
And the only person that holds the keys to that is the person on the other side that doesn't even own a majority of the business.
Oh
Um,
man.
you can't get into to prove up. You've got that all the emails exist that show that you're in the right, but you can't get into that email account anymore because they changed the logins for that too. So
Yep.
now, not only are you not able to prove up what you were saying that the written communications were, they might even be having uh, more email communications using your account with your name at the and signature block at the bottom that you don't see, and you have no idea that they're even happening, and they're putting you out there and signing on to all kinds of obligations for you with third parties, right? I've
Wow.
seen it happen.
That
Okay.
is rough.
And you would think, well, you just that's fraud, and you would call the police or you'd call the FBI, or that's all going to get sorted out in a lawsuit. Well, yeah, it's probably going to get sorted out in a lawsuit one way or another. Okay. If you call most law enforcement agencies these days, their response is going to be what? It's going to be, right?
I'm already assuming. Yeah.
This is a
It's
civil matter.
yeah.
You should go file a lawsuit, even though it
Yeah.
might clearly be a crime. They'll
Yeah.
tell you because they don't want to mess with it, right? They only mess with the biggest of the big fish in uh, in financial matters these days,
Right.
and they really want to be focused on violent crimes and bank robbery, right?
Right. Right.
And so you're not going to get the help there that you think you're going to, unless you're in a small town. I'll tell a story. I've seen one case that was just like that. It wasn't that much money involved, but it just happened to be in a small town. If you're lucky enough to be in a small town, you can get the sheriff, you can get the DA to open a case, and you can get the sheriff to come down there and arrest those folks and then prosecute them, right? And I've seen that happen because it's the only thing going on,
Yeah. That's right.
right?
Yeah. Not
They
a
might
whole lot
have
of
five
activity.
cases in a year, and this is like the biggest thing they've seen in a decade. It's
They've
not
got
that
time.
way in the towns that most people do business in,
Right.
right?
Right. None of the major cities.
It ought to be, but it's just not anymore.
Yeah.
So that's if I was going to give a last point, it would be get it in writing. What you said before the contract was signed, what you said after the contract was signed, even if you have it recorded, because I've had folks before that were like, we have everything recorded. We have all of this recorded. and it proves everything. But what they really have is they have, 30 hours of recordings. And some of it says the things that they like, but then sometimes they say things that maybe aren't so helpful.
Of course.
And when
It's
I'm deposing,
ambiguous.
that person that said all these things, I get 6 or maybe 7 hours to talk to them, and that's it, right? Without
Yeah.
special permission from the court, that's all the time I get. And so the amount that recording is really going to be helpful when they can say, well, somewhere in those 30 hours they said this or that.
Yeah.
Somebody's got to listen to that 30 hours of tape to know. Somebody's got to transcribe.
Yeah, that's a lot.
It becomes a massive blow up and a huge expense.
Yeah, that would be a lot to transcribe.
So get things in writing.
Yeah.
Get it in writing is the other thing that I would say. Yep. These are my points.
Yeah, we're going to have to talk again about me retaining you on my side of the world here. These are some pretty incredible points. I feel like, honestly, these are some of the things you said at the beginning. People get hung up on the most, and I mean, some of these I can assume as much, but then it's pretty surprising how it can go sideways on you pretty fast. And I can only imagine the struggle and just the outright pain and frustration once you scale it into hundreds of thousands or millions or even into the billions, and it's little snafus like this.
The thing I would tell folks is your mindset when you're making the deal should be, we want skins, not toys. And what I mean by that is, it cracks me up when I go talk with my deal guys downstairs at our firm, because they get, at the end of deals, they get these little things called deal toys, which is like, sometimes it can be any kind of funny little thing, and people actually pay to get these things made, but it's something that represents, like, we did this deal, yay, everybody's happy, put this up on your thing, and everybody made the deal, we're all doing great, we're making money, whatever. We talk about, in the litigation section, trial lawyers, we talk about skins on the wall, right? So we're not playing around. We're capturing, killing, and skinning things.
Yeah,
putting them up on the wall. And the way that happens is that folks in the deal making phase, they were thinking about toys. They weren't thinking about their skin being on the wall one day, right? Think about skins, not toys, and approach all of the things around getting into a deal, papering the deal, and what comes after it with that mindset, and you'll be better off.
Man, I absolutely love that. Again, we're going to have to talk about doing some work, and I'm going to need to retain you, Ross. But honestly, this is great. I love every bit of this. I hope those of you watching are taking extensive notes or are going to rewatch this a few times. Talk to your legal team, make sure everything's buttoned up. These insights, tips will save you tons of headaches. I can promise you that for sure. Ross, thank you for your time. Thank you for the insights. Those of you watching, I hope you enjoyed this as much as I have. To find more episodes like this on Behind the Deal, check out my YouTube channel or follow me on LinkedIn. Ross, thank you so much.
Thank you. Have a good one.